We're going to call this meeting to order, and would everyone stand for the Pledge of Allegiance? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. So, my name's Rick Ingalls. I'm the chair. I'll let the other three board members introduce themselves so everyone's aware of who's here tonight.
Ashton Cotton.
Ernie Wood.
Pat Bovair.
So we thought we had 5 members, but unfortunately the fifth one didn't come tonight. It's okay because we only need, per our ordinance, 3 to make a decision, and we have 4. So we have a quorum tonight, so we can proceed. So the next item on the agenda is approving the minutes. And before I ask for a motion, there's been one correction made to the minutes, and that is at the very bottom of page 1, the motion was 4-0, not 3-0-1. So those minutes have been corrected. They aren't here for us, but the minutes that I have to sign tonight, once we approve the minutes, we'll have the correct information. So given that I've told you that the minutes have been corrected, do I have a motion to approve the minutes of November 17th?
Motion to approve.
We have a motion. We have a second.
Second.
I have a question.
And that's it? So is there any discussion?
Okay. It says motion passed 3-0-1 on the above motion too.
Yeah.
Is that the same?
No, but that's because Ashton
Ashton
wasn't here,
abstained.
so he abstained from the top one.
Okay, and so the number at the end is an abstention?
Yes.
Okay.
Yes, that's correct, Pat. I think we've clarified Pat's question. Any further discussion on the minutes? We all set? I'm going to ask for a vote. All in favor? Okay, the motion passes 4-0, and we've approved the minutes from November 17th. The second item on the agenda tonight is appeal. Variance requested by appellants to allow the continued habitation of maintenance persons on-site apartment, number 8 George Street, basement apartment 4A, in the urban residential R1 zone. Our first meeting for a Board of Appeals went somewhat okay, but it was a little rough being my first one. So I kind of come up with a synopsis or a way I'd like to start these appeals, and so I think you all got a copy of that. But basically I want to just read to everybody that's here what I see the board doing, and then we'll follow through. The Board of Appeals is designed to allow residents and property owners the opportunity to appeal decisions by the town with respect to the town ordinance. The board is not a fact-finding committee. Our job is to just listen to the appellant, provide us information, and then based on the information the appellant provides us, we can act rather that there's been a issue with an action by the code officer or not. So I found that difficult because my first time sitting here, I thought I was supposed to run around and get all the information. And it's not our job to do that. Our job is just to listen and then act on whatever is provided to us. That is the responsibility of the appellant. The board will hear the concerns and ask questions and determine if there's a valid reason for the appellant's request. And then after hearing the appellant's request, we'll act on that if we find that there is a need. So that in a synopsis is what I think we're going to do here tonight, I hope. Following that procedure, what I want to do tonight is I just want to quickly, so that we're all on the same page, review what the code officer provided us so that we know we're all on the same page. And there it is right there. All right, so on December 6th, we received a letter, right, from the code officer, and on September 16th the code officer received complaints and went to 8 George Street And at that point in time, did a house inspection, and then, let's see, the code officer spoke with Mr. Letarte and advised that due to dimensional requirements, another unit could not be added to this property. So, because it's a .25 acre lot, there were already 8 units. There was also an electrical issue with the apartment in the duplex. It was being fed from the duplex, and the tenant was using another unit's electricity and not on its own for the last 3.5 years. Mr. Letarte stated that it needed to get a tenant out immediately, but the tenant was giving him a hard time about leaving. Mr. Letarte also said that he wished the town could help him evict the tenant. When questioned about the electricity, he stated that he would have it fixed as he hired a local electrician to do the work. Mr. Letarte stated the apartment was already existing and that this was not the case. Mr. Letarte's lawyer stated that this apartment was already existing. Mr. Letarte came in to talk about putting the apartment in about 2018 and early 2019, and he was told no then. On November 15th, Mr. Letarte came before the code officer with a building permit. The permit was denied. So at that point in time, the permit was denied, and there was a notice of violation sent on the 20th, and that the apartment needed to be evacuated immediately. Proved that the laundry room and the legal apartment electricity was being fed off a separate line, and if that wasn't done, then there would be fines per the ordinance, and if he wanted to appeal that decision, that he could appeal the decision. I believe, unless, and I'll look to the code officer, if I pretty much encompassed exactly where we are right now with this at the board.
Correct.
Okay, so is the board clear on where we are right now? We've got a violation, been denied, and Mr. Letarte has brought a variance to us. So we've never done a variance before, so let's go to page 120, and we'll just go over the rules for a variance so that we're all under the same understanding. So on 120, we're at 10.4 variances. Variances may be permitted only under the following conditions. A, unless otherwise provided in this ordinance, variances are obtained only for height, minimum lot size, minimum lot width, structure size, setbacks, and open space requirements. So those are the rules that we can act on here tonight. Any questions on what those words state? Variances cannot, under any circumstances, be obtained for establishment of any uses otherwise prohibited. And then there are the 4 requirements for getting a variance, that if the appellant meets one of the requirements, then we'll go through the 4 rules. So, having said that, are we all set there? Are we clear to some extent on what our obligation is?
Clear.
So I guess I'm going to ask the lawyer for Mr. Letarte, just to explain. I wasn't exactly clear. I probably can infer, but what you're asking, what are you asking this board to waive, or what's the variance requesting?
Variance of lot size.
So you want us to look at the minimum lot size
Correct.
that's on here. Okay. So does everyone fully understand that where we're headed with this variance tonight?
Yes.
So, having said that, I think we are all set to hear from the lawyer for Mr. Letarte.
Thank you. For the record, my name is Brian Barrington. I've been a member of the Maine Bar since 1986 or so, 3113. My office is in Somersworth, New Hampshire, across the way. So to give you, after receiving the notice of violation, Mr. Letarte did not ignore your code officer. He did two things. One, he contacted our office and we initiated an eviction. Just because something is illegal under zoning doesn't mean that the tenant can be summarily thrown out of his apartment. We have to go through what's called the FED, or forcible entry and detainer process, to do an eviction. And a notice to quit with a 30-day notice was provided. Nonetheless, we feel very badly for Mr. Emmons and wanted to try to preserve his right to continue to live in this building. It is not an appeal of the administrative decision. It is, it's a request for a variance because you appeal for an administrative decision if you feel that a use is grandfathered. In order to be a grandfathered use, and we would have to prove that this apartment was in fact occupied as an apartment prior to the date of initiating of the zoning ordinance, land use ordinance in Berwick. We've determined that, I put in my written material that he's been there 5 years. I just asked Dennis Emmons himself, who's present. He said he's actually been there for 8 years. But Berwick zoning and land use regulations are older than 8 years, so it's not, we can't claim that it's grandfathered. And so that's why we're asking for a variance. So on the attached, there's an attachment to the variance request, which presumably you guys have in front of you. It's certainly, it's certainly not an easy case. The purpose of the variance procedure and why we have a zoning board of adjustment is when the strict adherence to the town ordinance creates an unnecessary undue hardship. And hardship is a broad criteria. And we're asking the board in this situation, to look at the unique terms. The things you'll hear over and over again in terms of hardship is that hardship can't be based upon a pure economic loss, and that the hardship has to be related to characteristics which are inherent in the land and building. So that's the force we know. So first, we point out that we really hope that the Zoning Board of Adjustment can act as this safety valve for the public good, because certainly there is a severe housing shortage in the Seacoast region. And zoning discriminates against the poor. It just does. Here in Berwick, you have a downtown area that typically had mill workers in fairly high density. The building has been there probably since the 1800s, or at least probably late 1800s is when it was built. And it was built in order to allow people to live there. Now, it could very well be that back in 1889, there probably were people living in this particular room. This is an efficiency unit. It has a bathroom, and then it has an open concept room that has his bed and a kitchenette against the side, and it also acts as his work area. And it's when you say that you have to have 10,000 square feet for each unit, obviously in a downtown area that's impossible. Now, if this was to be built out in the country, that's another matter. But there already is, let me just double check to see. Right now in this building you have how many units? 6, I thought.
Oh, 6.
There's 6 units. Someone said 8, so I was surprised about that. There's 6 units, and that would require about 1.5 acres, and obviously that's not available. So the physical characteristic inherent with the land is that this is a apartment building that's been in existence for nearly so what is that, 120 years, with people in and out over times, and you can't get additional land. It's all wedged in. Secondly, we're asking you to look at the unique use of this particular. He is the maintenance person, not only for this lot and the 6 units there, but my client has 11 apartment buildings throughout Berwick, and he is the local rapid response maintenance person, super person that goes around and manages those repairs, does the snow walk, clears the snow and ice, and maintains the buildings for the benefit of the owners. So, it's kind of like the dilemma you have in a rich area with a lot of big houses. You need some cheap housing for the people who service the big housing to have a place to live. And this is a very modest and small unit, but it's home to him, and the area benefits from having someone who's local, doesn't have to drive in from abutting places. So the unit itself is also the workshop. It's the workshop. It has the storage. It has the parts that he needs. And that's also how this particular unit is used, and that makes it a unique unit inherent to its use. In terms of the electrical issues, health safety is never something that you get a variance from. Crichton Electric is working on the problem. They're working with the code officer, pulling permits to do the electrical work necessary. I'm told that those permits are in the process of being applied to, and they may not be applied to. And obviously, whatever this board does doesn't excuse him from having to clear the electric issues, because the electric is life safety. So the competing equities, the return not just for this building but other buildings and for the benefit of the people, we're asking that Mr. Emmons not be thrown out and allowed to still be able to live there. Number B is unique circumstances of the property and the general conditions of the property. I think we've already addressed that, the factual issues. There isn't a single building in the downtown area that has 10,000 square feet for apartment. It was an arbitrary high number put in order to reduce density for the future. But smaller apartments with more density is what's necessary for people. C is probably the easiest one here, because it's not going to alter the essential character of the locality, because he's been there for 8 years. It's not going to change the density, the use of the building that's already been there, experienced. And it's, as a single unit efficiency, it's a one-person apartment. It certainly doesn't change. Mr. Emmons is not changing the character of the neighborhood. And then the hardship was not a result to the applicant. The building was built well before Mr. Letarte. He thought it was okay to have someone live there. Someone's been living there for 8 years, and now, due to this enforcement action, he's got to either evict them or try to get a variance. I don't know if Mr. Emmons wants to say anything in support of it or not, but I assume that I make the public hearing, you want all the members of the public to say what they have, and then you go into deliberation, and then if you want to ask questions, you can call me back. That's the way we usually do it.
That's true. A lot of times, if there's a question while you're standing up here that a member would like while you're still at the podium, we certainly can ask questions at that time as
So
well.
I can, at your pleasure.
I guess
I'm not going anywhere.
the biggest issue that I have with this is D. And it's not just that it's the applicant, it says that the prior owner. So basically that goes back to for as long as it's owned the property, you can't have done something to cause the hardship. And I'll use my house as an example. Right now, we put on a game room on our house that my mother-in-law lived in when she could no longer live, on her own. We didn't come to the town for another occupancy permit. It wasn't an apartment. It was just, we all lived in the same house. She just used that room because she couldn't live in her house alone. If I was to advertise that as selling it with an apartment in it, I would expect that I'd have to go to the town and say that now it is an apartment, and I'd have to meet all the requirements that would be enforced by the town. So you can own something, and it can be a space that's a livable space, but that doesn't mean it's an apartment. This is an apartment. You're stating it's an apartment. It had to have been created by somebody. So I guess the question I got is, you don't want it to be grandfathered, but at the same time, someone put this apartment in. Do you have any knowledge of that?
I can shed a little light on it.
Would you step up and speak, please?
Absolutely. Back some years ago when I came,
Mention name and address.
Aaron Netto, Berwick, Maine. When I first started working for Jerry Latire about 10 years ago, I was in need of some help. He's got a lot of projects, and so I brought in Dennis. He's a 26-year friend. I brought him in to work with me. Times were getting a little tough for him. He was spending a lot of late nights working with us, snow removal. I mean, it just goes on. So a little at a time, we kind of chipped away at the work area and made it livable. Because, times were hard, money tight,
Right.
and a lot of late nights in Berwick. So we took advantage of the space more so than Jerry Latire. And, we refer to it as an apartment because everybody else has. It was kind of just a space and, rest your neck in it. And, time went on and we took advantage of it. Not because we wanted to, because we had to. And it made sense for the business itself. For the fact that we're a very small crew. This is what we got.
Right.
And we're called out every single night, just about. And we have to take turns being on shift. And nobody wants to get up in the middle of the night and run out here to these apartments just to reset a boiler. And so, we're to blame, a lot of it. We took advantage of a space. And we're kind of, now we're here trying to fix it all together.
Right. Thank you.
So he gradually spent more
Would
and
you
more
step
time.
up to the podium just because we're on camera? Thank you.
So my understanding is that people have been crashing in that room for a long time, and then instead of just crashing after doing some work, then he started staying there more overnight. It's never has been an apartment for rent. It has been the maintenance room. And as using a fancy word, as an accessory use to being an on-site maintenance room, he added a bed. As an accessory use to having a bed and doing maintenance in the building, he added a bathroom so he could use a toilet. And it's not rented for profit, but it's for the convenience of the building. I mean, that's the facts. Whether that I mean, there wasn't an intent to rent this out as an apartment and create his own hardship, but it was a necessity of business to have a place where someone could stay. And those are the facts, and that's the way it is.
Is there anyone else out in the audience that wants the opportunity to speak? Okay. Would the code officer like the opportunity to speak?
Of course.
Thank you.
Very first came into the code office in 2018. It was like the winter. So it could have been early 2019, but I'm pretty sure it was that December in 2018. And he asked if he could create another apartment in his building. At the time, the code officer was Dan Vincent. Dan told him no. So 8 George Street, just to give you guys a little history about our land use ordinance, it's right outside the village. It's actually one lot outside the village. So anybody can come in and go in front of the planning board and the select board and ask for their lot to be inside the village when they're that close. There's actually, believe it or not, there's another lot on the other side of the road that is asking to be inside the village to turn into a apartment building, which is a single family house now. 90% of the time those go to town vote, and the town votes them in and says, yes, of course. They're down there, they could have done it. I told Jerry this over, in the office a couple weeks ago. But anyways, go back to 2018. He was told no, simply no. And it's true, he can't. Density doesn't allow it, okay? Now, we in Berwick wouldn't allow an apartment to go into a basement or any kind of building to be rented for any kind of maintenance use unless it was like a legal apartment. So it would have to be permitted. There would have to be running, there would have to be a stove in there. There would have to be, a running toilet. There would have to be a sink. Doesn't have to have a bedroom. Doesn't have to have any. That could be a studio. But it would have to be permitted, and it would have to be okayed by the code enforcement officer at that time. I can tell you that if you fast forward, so he was told no by Dan Vincent. I'm just going to read some notes. Fast forward to 2021. Now we are here. We received an anonymous call on September 16th. And that anonymous call, unfortunately, was, it probably felt like, to Jerry and his crew, like, the town was dogging on him a little bit. If I was him, I would have felt that way. There were 9 violations that were brought to our attention. The illegal apartment was one of them. And then how that apartment is being fed, it's being illegally fed from the duplex out front. So where he said, I don't know where you got the 8 units from, that lot has 8 units on it. It has 6 in the apartment, and then it has 2 out front. They have a building permit right now to renovate one of the front apartments in the duplex. I can tell you that Tim Creighton has not yet been hired to fix that. I talked to Tim on the phone this morning. He was going to look into it, give Jerry a quote, and then go from there, but he has not yet been hired.
You signed a check today.
Go ahead.
Yes. I
Please.
signed a check.
Hey,
Today?
Please.
Today, yes.
Okay, well, this was as of 10 o'clock this morning, so that
Okay.
probably happened after. Maybe it did, I don't know. I can only go on the facts that we have.
Right.
Um,
Just one second.
Yeah.
So you certainly hold your comments and raise your hand, and certainly I'll let you come and address any concerns.
Yep. All right, so another thing is you're calling it 4A. It's not, it does not actually have an apartment number. I want to make that clear. Letters were sent to Jerry. He never disagreed with the illegal apartment. He's never once come to us and said there's nobody living there. He's been upfront and honest about it the entire time. He was even upfront and honest when we called him out on the illegal electricity issues. He said, we'll get them fixed, no problem. He's never denied them. He did come into the code office many times, and Tammy can witness that. She's been in there when he's come in. He wants the town's help to get this tenant out. He doesn't want the tenant there. That's what he keeps telling us. Members of his management wouldn't help him. They want to stay out of it. They don't want to get involved. That's just what he kept saying. Nobody will help me. My managers won't help me. No one will help me with this. I told him we were unable to help him with this too. It was a no from us. He said, my tenant can't move. There's nothing for him to move into out there. He needs this apartment, needs this apartment. That's typical, something we would hear. The letter that came in from the lawyer said that at one time that this was possibly a rental unit. So it said that this building was put up in 1900s. It was a unit, whatever. I can tell you as of 1998, and our land use was before that. It was not, because I grew up in the apartment adjacent to that, 4B, and I can tell you that we used to play downstairs in there, and the laundry room and that apartment were not in existing at that time. And again, we moved out in 1998, so I know, but prior to that, it was definitely nothing that was there. There was no bedroom there. There was no anything there. It's where Jerry used to store his stuff, you know. Other than that, I, as a code officer, I don't have the ability to grant them density for that apartment. I don't. I have to follow our land use ordinance. Our land use ordinance says that there cannot be an additional apartment in that building unless they wanted to come in and provide information to the planning board, talk about it there, and then go from there. They could go to town vote to see if that they could be part of the village overlay district, which would allow him to put more apartments in that building if he wanted to. But I can't help him any further. That's all I have to
Sounds like
say.
There's a potential clear path to make it legitimate.
There is. There's a few. Yep.
I'm going to ask a question. If, because I'm not quite familiar with how this would all work.
Sure.
If this board was to allow make a variance to the minimum lot size, there's still no permit on this building. Would the applicant have to come in and get a permit for this, even though knowing that we waived the lot size?
His permit's been denied for this building.
Because of lot size.
Mm-hmm.
So if this board,
His permit was denied after he filed for this appeal.
right, but I guess what I'm saying is, I'm just want to know if this was allowed. This board agreed that the minimum lot size for this apartment could be waived. Would he have to come back in and get a building permit for this apartment?
Yes, and at that time, we would turn it over to our town attorney to see if we would even issue one. Yes.
Because you said that you saw 9 violations, is that?
It has nothing to do with the violations. The only violations that are like in existence of this apartment that deals with this, but particular case, would be the illegal apartment and the illegal electricity feed into this
Okay.
apartment, where another tenant is paying for the electricity of that apartment.
Certainly. Yeah, I certainly understand that that's an issue, so
Yeah, those are the only 2 issues that would be. Everything else didn't really have anything to do with this in particular.
right,
case.
okay, that's really, I'm just trying to, that's what we're here for, is to
Sure.
get all the information, gather it all, so that we can, act on all the information we have available.
Sure.
You had a question or a comment?
Yeah, I just wanted to correct it.
Can you
Just go
stand
to
up, please?
podium. Yep.
Yeah, I wanted to correct it. Nobody else is paying for the power but Mr. Latar. The power is being run off the other building, the project that we have a permit on that we're renovating. That's where the power is coming from.
Thank you. Any other comments or questions from the public? Okay, at this point in time, we will close the public portion of this hearing, and the board, like the lawyer, I'm sorry, I forgot your name.
Barrington, Brian Barrington.
Mr. Farrington mentioned we'll discuss, and if we have questions, we will ask people to answer any questions that we might have before we act on any of the items here. So, having said that, I will close the public comment portion, and I'm going to look to the board to, was there anything that you were confused about, or any questions that you wanted to bring up? Between us first, and then So you want to ask a question?
Yes.
All right, go ahead.
So I'd like to know why Mr. Letarte does not want to go ahead and try to join into the village overlay district so he can make
That-
legitimate.
Excellent.
And that'll, well, we're having immediate, we have a cease and desist order with a $100 a day fine penalized. So we don't have the luxury of waiting until town meeting in the spring before he has to vacate. So we're just trying to hold on to it,
Bridge the gap.
yeah.
So you are
I do
taking-
have a copy of the notice of terminate tenancy that I filed, just to
So-
show that we did that as well. We haven't filed it with the courts yet.
What is
The
it a
date
notice
goes up
for?
to December 3rd. The
I'll
eviction
pass it
notice that
around.
I gave Mr. Emons. Did that answer his question?
Terminate. This is a
The selectmen
termination
can always
of his,
rezone
pass it
it.
down the path.
That takes time.
Anyone else have any questions? Ernie?
Mr. Barrington, I'm reading your letter to us. And I've gone over it a number of times. And I have a couple of questions for you. Just so you know, I'm a person that I operate in terms of making decisions based on fact rather than opinion. And everybody's got an opinion, but sometimes it's the facts that drive the results as opposed to opinion. In your second page, it says the apartments here, under A, under the variance, it says the apartments, I know there's some opinion above there about, the history and so forth. It says, the apartments here and on adjacent lots cannot yield a reasonable return without this maintenance man being available. So in my opinion, that's, or my read on that is that that's an opinion, that it's not based on, it's not based on, I guess my point is that another maintenance person could be hired. Another firm that does maintenance could be somewhere off-site. So to say that this maintenance man and this apartment or lot here is so it can only be that, or there's no way of having a
Alternative.
income. And so I was just curious as to that piece. The other thing I have a concern about, and I don't know if the code enforcement officer has jurisdiction on that, and that is, in your brief here, you have indicated that this space is also a tool room, a storage area, a workshop, and some living space. Is that correct?
That's my understanding, yes.
Okay. So one of the things that I would have a concern about is what's in that space other than the living space with regard to chemicals, gasoline, I don't know. I'm just saying that if it's a storage, a tool room, and a workshop, and a living space, all in a space that is called 4A, from our point of view, how does that square in terms of its use? And it might have some bearing on whether or not we can act. But we're not code enforcement officers, and we're not people who have, concerned about other people's health. But I have a question about that, so I don't know how that and it's in your brief, though, so I'm raising that question.
So to answer your first point is Mr. Jerry Latart's position that he wants to have a person living in the midst of the property so they have immediate response, and for, as you heard, when there's late night work, he can come in and out. And it's not that he'll make no return on his investment if he had to hire other people, but we think it's reasonable return on investment would allow him to have a maintenance person on site for the benefit of all those people. In terms of what's stored in the unit, I mean, I can ask Dennis to say what he has there. I don't think he has. You tell us, do you have dangerous chemicals or gasoline?
Yes.
Sure, they want to hear from you. Just say your name and address.
My name's Dennis Emmons. My address is 8 George Street. And there's no chemicals whatsoever in my apartment. I just have my own hand tools, tool bags, stuff like that, just in case I need it right then and there. If I have to work on something right then and there, then I can. But there's no chemicals whatsoever. That it?
Do you have some like hardware or locks, or my understanding is there's some parts there?
Yeah, I have miscellaneous parts laying around. If we have to change doorknobs and
Right.
smoke detectors, and just all basic things we need for the apartment, just little minor things. Nothing with anything like that that can ever happen. Thank you.
What, I'm going to ask the code officer, what would be required to get an extension into the village? What's the process for that?
They just have to write a formal letter. They have to come in front of the planning board, share their want for that. The planning board would tell them to go in front of the select board at that point. The select board could put it on the ballot for June, and because of where that building sits, 90%, as long as the town was okay with it, they would be in the village.
So it's, and I think you said that too, Mr. Barrington, I just want to be clear. So basically, there's a process, and it would play out till the next vote for the
Yeah.
change in the ordinance. Because the
Yeah.
ordinance, and that makes sense, the ordinance has to be changed to allow that to happen.
I can't allow it.
I understand.
The ordinance has to say it. I just want to make that clear. It's not something that
Right,
can just
it's not
say,
a personal
oh, sure,
opinion.
just do it and go ahead. It's
Right.
not. It's fact. It's our land use. It's our law. It's our town
Right.
laws. You know. I also want to say that. What was I just going to say?
I don't know.
I don't know. It will come to me.
It'll come back.
Yeah. Oh, I also want to put on record too that say, Mr. Barrington has come before you, and told you that Jerry would love a maintenance man on site.
All right.
Can I keep going?
No, I don't think you
Okay.
can, because you're not answering a question, and
Okay.
then we'd be opening up public
Sorry.
comment again. No, that's
Okay.
all right. I wouldn't be comfortable with that.
No worries.
So, do we have any other, Pat, how are you doing over there? Do you have
I'm
any?
feeling very uncomfortable about all of this.
Well, what do we need to help you clarify any of this?
I mean, I am all in sympathy for Mr. Emmons. If he's such a valuable person to Mr. Letarte, I would think Mr. Letarte would make sure that he had a legal apartment already, and that if he realized that this was going to be an issue, that he would have already tried to put in his information about becoming part of the village overlay. That option has been available for a long time now. I don't know how long, that you can, ever since the village overlay was put in. To me, it sounds like just an avoidance and trying to not have to do anything unless you're forced to do it. I think this basement apartment sounds, it's not appropriate. It shouldn't be there. That's my opinion. And I do feel that if we allow this, that there are going to be many other little basement maintenance facilities that would like to become apartments also. I do feel that it will have an impact on the neighborhood. I do not see any reason why this board should be allowing something that's already non-conforming to R1, which is what you're in and which you have not made any arrangements to change. You're asking us to make something even more non-conforming than it is. And that isn't what the zoning ordinance is supposed to do. Anything that's already non-conforming, the only changes are supposed to be for something to make it less non-conforming, not more non-conforming. So I feel like that's not appropriate. I also feel like the lawyer is giving us, the emotional piece about all this, which we, of course, all agree with. But then Mr. Letarte, coming into the code enforcement officer previously, says, I want to get this guy out of here. I want to get him out. I don't have any way to get him out. I need the town to help me get him out. It's like something isn't jiving. And we really have the dimensional requirement in R1 right now, and adding another apartment to this, which has already been denied to Mr. Letarte. He's already tried to do this before, and now he's trying again. It's like, what are we doing? Trying to, to me, the whole thing just doesn't make any sense. I think that the variance for the lot size, which is what the lawyer is asking, I don't think it's appropriate for us to give, because we're making something even worse than it is already. So those are my general feelings.
And I think basically there is a process that's more than likely going to allow that to happen.
What to happen?
That to get redistricted into the village, and that's not being pursued. So, I mean, it can be. So it's not like it's not an option to do if that was so chosen to be done. I know it's inconvenient
And
because
it's expensive, but you know what? Everyone else in town who has an apartment and who lives next to the village overlay, that's been the talk of the town. Do I want to be part of the village overlay? Do I not want to be part of the village overlay? What do I have to do? So the fact that it's being brought up and it's being forced, like, pay your dues.
Right, yeah, the option's
Yeah.
there.
Plenty of other people in town are waiting or deciding and that kind of thing, the same issue. And if we want to give him some kind of an extension so he doesn't have to pay the fines or whatever, is that what was?
That's what they're looking for, from my
Yeah,
understanding.
it's like, oh, well, you should have anticipated this and done this. Everyone else in town is concerned about the same thing, and if we give that to you, we're giving that to every other person who, I don't think that's
I will ask the code officer a question, now that you've brought that up, Pat. I don't know exactly. Right now, there's an eviction process going. Is that true? Well, no, we just saw it. There's an eviction process going. So they're in the process of trying to get the tenant out. If it was just a matter of, once the tenant's out, they're going to have to come in and get a permit. And like you said, you might have to, I'm talking about if this was waived, if all of a sudden we agree that this is allowed to happen. The tenant's out, still gonna have to come in for a permit, I hope, because that's what everybody else has to do in the process. I mean, just because we waived the minimum lot size doesn't mean that the apartment exists. It still would have to come in and get a permit and go through the permitting process. The only thing I can see, what Pat brought up, is that the fine is being incurred every day while this is happening. Is that true?
It is true. We have no court date pending right now, and we have nothing on the docket to bring Jerry to court as of now for this. So, and that's who the judge would.
Oh, the judge would be set, and so right now there isn't a fine. Was it retroactive or?
From the date of the first letter on September 20th.
Right, so from that point on, if the judge found that there was a violation, then there would be a fee assessed based all the way back to
That's correct, and the fee is $100 to $5,000 a day.
a day.
Every day the violation is in existence.
Okay.
Well, I guess in 2018, when the apartment was denied, that maybe over that period of 3 years, Mr. Emmons could have gotten himself a real apartment in one of Mr. Letart's apartments, if he's such a valuable person.
So you're talking to me, right?
Yes,
Okay.
and that, you know, if he's so valuable to me, Mr. Letart would have made a spot for him.
Right.
So that he could keep going, and they could have worked out some kind of a deal.
Right.
But instead, it was just shovel it under the, you know, just put him in there and know that he wasn't supposed to be there.
And given the benefit of the doubt, because things can happen, that at some point in time, there was a realization that they needed a permit and it was denied. And that's what got us to here. I mean, if they'd gone back for the permit back 5 years ago or 6 years ago when this started and it evolved into what it has now, it would hopefully have gotten corrected way back then. I mean, we all need permits in this town to do things. I mean, that's the nature of the beast. That's what the ordinance is for. When you go do work on your house or you have you have changes in circumstances, you need to get a permit.
Right,
to go do
and
that.
it's always nice to try to avoid those. And,
Right.
you know, when you're a business person and when you're a person who's already been told something isn't illegal, it's like,
Right. And, I mean, and having said that, I do think this is worthwhile and I like having the conversation. My biggest concern, the other ones, I think we could work around. D is my biggest concern. The hardship is not the result of the action taken by the applicant or a prior owner. Well, yes, it clearly is the result of someone doing that. So I'm not sure how I find that we can grant this variance when the ordinance says right here that if it's an action taken by the owner, then we can't grant that variance. That's my hardship on this whole thing. Am I missing something there?
Pretty it's black and white.
I don't think so.
Ernie?
To the code enforcement officer, if I may, is this space, I assume as code enforcement officer, it's not just about land and size and so forth, it may be health issues, might be, you know, hazardous, whatever. Is that under your jurisdiction or not?
The health officer is our town manager in town. I can tell you that I personally have never been into the apartment. So I can't answer, I don't know.
I'm just wondering, when you denied, or when you're denied the initial request, where you didn't have any, did you have concerns about health, or in other words, could be inhabited, that space? I'm concerned about, it's because the space is going to be, what I hear from the appellant is that they want to create a space that's an apartment, but it really is a living, there's somebody living in part of it, and there's a tool operation and a workshop and storage is also part of this.
Yeah.
So does any of that apply to your concern or denial of this originally?
A couple things here. So I actually really enjoy working with Jerry, and I really enjoy working with Aaron as well. I find them very easy to work with. If I ever have any questions, they're great. I don't know. I've never had an issue with either one of them. But I will tell you that if this was in the village overlay, Jerry would have been granted a permit for this apartment to add to the building. At that time, he would have gone through framing inspections, insulation inspections. We would have given him final occupancy for it, and there would have been some things that were questioned. If he had a workshop down there, it would depend on what materials were in that workshop. If there was chemicals there, we, code office, and the fire department would request, the data sheets on what the chemicals are in there, and then we could go from there. But without seeing it and being in there and not sure what the materials are, I can't answer that question.
What do you think, Ashton? You got any questions or anything?
I think Mr. Letarte should have pursued the village overlay some time ago and made it into a good place for Mr. Emmons to live.
And he
That's
still
how I feel
can.
about it. Yeah, it's still there. Just you're going to be accruing some fines until you can get that done.
Ernie?
Is, I think what Pat is saying is, to me, sometimes common sense has a real place in this. And unfortunately, some things that should have been done weren't done. And if the appellant is serious about having a maintenance man on site and available 24/7, then common sense tells me that the person who owns the property would make that happen without having to go through all of this. And that's, to me, just common sense. And I realize there's a lot of ins and outs of this issue, but we're probably, in my opinion, not ready to make a decision unless we have a lot more information and also develop what the legal status is of this case.
What information do you think you would need, I guess?
Well, I'm concerned that if, let's say, I don't know the process, but you just said that you could appeal to the town to get a change in the land use ordinance so that if they're in the village, what does that mean in terms of having an apartment, so-called apartment, that has living space, storage, tool room, and workspace? There's a lot of uses there. And all of those uses permitted? I don't know about that. I don't know how that works. If somebody is operating, wants to operate a tool shop somewhere else in town, and then they want to add a little piece of room for a bed and hot stove and whatever, toilet, or is that how that works? I just
Well,
don't.
that's the permitting process, and
Right.
that's, I think, what we asked, if we were to agree that all four of these variance parts were met for the minimum lot size, wouldn't change the fact that the permit is still, there's still gonna have to be a permit issued to allow this. All we're doing is saying now, it would be like what was mentioned is, if it was approved right now by the town to put this into the village overlay, then he could come to the town for a permit. The permit would have to go through all the necessary requirements for the permit, so that wouldn't be our call. I mean, that's going to be back to the town's call whether the building is an adequate space to be apartment. We're just saying the minimum lot size is okay. We're going to waive essentially the minimum lot size for this and then go back to the code officer to reissue a permit if they meet all the requirements for a permit. We're just saying it's allowed, the lot size would allow its use in that building. You following what I'm saying?
In the village overlay.
Yes, because if it was in the village overlay, which we're fairly confident that if the process was met, that would be accepted into the village overlay, then Jerry could come to the town and get a permit because the minimum lot size wouldn't be there anymore. So, again, one of the things that when I sit on boards, and I've been on a few of them, is, and this probably goes against everyone that's going to come to this board in a sense, but I hate to set precedent. We have rules in here, and the minute you make an exception, it's kind of like what's brought up. It never seems to end. Someone else, I mean, that's why we have the ordinance. But I'm not making that decision based on that. We're going to look at these rules and make sure that the rules are met. And I'm still going to get back to D, really, unless someone in this board can convince me that how D is met, I don't know how we act on this. I mean, clearly, this was caused by the owner or a prior owner. This didn't become, the lawyer, Mr. Barrington, said that they're not pursuing the grandfather issue. So we're not talking about before 1985. So it wasn't, essentially it wasn't in existence before 1985. That means it was made an apartment by somebody, not us sitting here at this board, and I don't see that we have the authority to grant that because it was made by the owner.
Self-inflicted.
Self-inflicted. And it's not personal. I'm having a hard time getting over that rule.
So,
Yes.
So, may I speak?
Yes.
So that D, really, when it says here, it says the maintenance unit has always been used for that purpose. And I guess the issue that I see is that this is in some ways opinion, but not fact. And the facts are that whatever's happened in that unit is the result of the owners taking part in that, making the changes, not something else. And
Exactly.
therefore,
Right.
your point is well taken.
Yep, Mr. Netto told us that 10 years ago or so he started to make
Right.
it. So it, it came about then.
So have we discussed this to the point where we're comfortable with what we think we're going to be able to vote, how you're going to vote on the following items? If not, that's what we're here for, is to get whatever information we feel like. And before I think about that for a second, I do want to ask one question. I'm pretty sure I understand, but these items, all four, if they don't meet one of those, that's it, right? It's not like you have to meet all four or anything like that. If this board decides that they don't meet one of the four criteria, and that would be a majority vote of this board, right? So, and I will say, I guess, well, I'm going to ask for clarification as well, because we have a board of four. So what happens if we have a 2-2 vote on an issue? What does that do?
However the chair votes is what passes it, is my understanding from legal counsel.
That it would not?
It would.
It
would.
would.
So hopefully we don't get to that point, but if we do, we'll have to
If we go down and look at each one of these questions, or can we talk about them
Absolutely,
individually?
absolutely.
Okay.
I'm okay with that. I mean, I'm just trying to get all the gist of everything. And to be quite honest, I don't know how legal it is, but I would like to start at D.
This is what they're talking about, just so you have it.
I don't,
And if
can
we
kind of
start
read
at D,
I
then
think
Far as
all
we
of them
go.
have to be voted on.
Correct, you have to vote.
we have to vote all of them? Okay,
All
sorry about that.
four individuals
Thanks, Pat.
have to be voted.
Okay. So,
I mean, you're welcome to vote, but we can also just withdraw the appeal. I mean, it's clear how you're gonna vote.
I'm sorry, I can't hear you.
If we want to be able to send you home sooner, we can state for the record that we'll withdraw the appeal, go forward with the eviction. I mean, you've already said what you're gonna do, so.
if you're comfortable with that, I mean,
Mr. Letarte says he'll withdraw the petition. I mean, we wanted to just do what we could do.
Microphone. It needs to come
You-
up. Yeah, they can't.
Sorry.
Mr. Letarte withdraws the petition. We did want to see what we could do. It's clear. We withdraw the petition.
duly noted.
And when we thank you for your input, I mean, obviously a lot of facts came out today, which is very interesting that I wasn't aware of.
Thank you.
Do we need to follow through with this procedure?
I don't know.
Oh, it's the end of.
I've said it for the record. I'll send you a letter too.
That would be the best way to do it, is to also send the letter, but because it's on the record now that he has withdrawn his application, you don't need to make any decisions at all. No decisions, because that case no longer exists any longer. He withdrew the application. The appeal application for the variance has been withdrawn.
Understand that.
Okay.
I just want to put on record, Brian, that if you have any questions about adding that to the village overlay, please call me or come in and we can meet and I can help you with that process.
Thank you.
Okay. So with the appeal being withdrawn, that, I believe, ends that item on the agenda. And that, I flip this over.
Thank you for your time. That's very important.
Thank you. That gets us to, I do want to, while we're here in the meeting,
Are we still on?
yep, we're still on, real quick.
Keep the on the wall.
We do have two items that are still outstanding, and that was the board policy paperwork and the work for, we wanted to modify the applicant's fact sheet. We still have those two outstanding.
I thought we decided how we wanted to
We
change
did,
it.
we did, but then it never came back. We sent
Oh.
that for corrections, and it never came back
Oh,
to
okay.
formally be accepted by this board. So
Okay.
would you be interested in meeting the second Tuesday in January?
Second Wednesday.
Second Wednesday, geez, I get it mixed up, all right. Second Wednesday to have those two addressed, and we can approve the minutes at the same time for this meeting? Would that be okay with everybody? I know it's over the holiday season and winter time and everything, but I just thought that way we can get that all done, and then we don't have, then we can maybe skip a meeting, and then maybe in March or something, we can have another workshop on another issue that we might want to discuss. All right, so I think that's noted in the minutes, that we're going to have a meeting in January, the second Wednesday, to,
Calendar. Day.
I think 5th, 12th. Yeah, I think it's the 12th, because I think I have a negotiating meeting for the union on the 5th, and I'm sure that's a Wednesday, or at least I'm thinking it was.
January 12th?
Is that, that's Wednesday, do you check in?
Yes. Yep. Yeah, that'll be the second Wednesday, January 12th.
This
Yep.
came
January
from the
12th.
lawyer, I think, or from you.
I have it. It's the
2022.
lawyer's paperwork.
Okay. Yes, 22. That was the only other thing I had.
At
I just
6:30.
wanted to bring that up before we close the meeting. Yes,
Rick, would you be able to meet with me before the meeting so I can make sure I've got the two documents?
absolutely, absolutely, for sure.
At the stage where you remember them being there.
That would be
I
helpful.
remember one came back, but
Yeah,
I'm still not
That's fine. No, I think it's important that we do. I certainly will sit down. I have off between Christmas and January. Are you working any of those days?
Yep, we're only open Monday and Tuesday of next week, and Monday, Tuesday, Wednesday of the week of the new year.
All right, so that'll work out fine, because like I say, I do have that week off, so it makes it convenient for me to stop in. So I'll send you an email and check in to make sure you're there, and then I'll stop in. Okay, great. All right, so
6:30.
that was, yes, it would be at 6:30. So I need a motion to adjourn.
So moved.
Got a motion by Ernie, a second?
Yeah, I just,
Pat's a second?
no,
And
I just wanted, where are they now?
They're going to
That's
be
what
looking at paying a fine once they go to court, right?
Yeah, so basically they'll have to file that letter with the court to get him evicted. We will be bringing them to court over it anyways, unless he tears everything out and we can see that. Should we stop talking? Okay.
They're not here, you can't discuss the case.
Oh, okay,
They are not
okay,
here.
all right.
Great.
I just didn't know how.
Where we are at adjournment. That's where we are now.
There we go.
Yes, I
all
vote.
in favor? Ernie, you in favor, or are you abstaining? All right, 4-0. Sorry about that.
That's okay.
No, I appreciate you helping us out.
I've got to say, I appreciate you
44.
both being here.
7:44.
Rick, hit the gavel thing so she